We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, good morning, and welcome to today's remote sitting of the Appeals Court. My name is ARIEL Vuono, and I'm joined today by Justice Peter Sachs and Justice Catherine Hand. Two quick reminders before we start today's arguments, and that is first, that the rules of appellate procedure in terms of oral argument apply to remote sittings, just as if we were in the courtroom. So you each have 15 minutes to present your argument, and there is no rebuttal in the Appeals Court. And the second is, upon occasion, which we've already experienced this morning, we have a small glitch or two in terms of the technology. If that happens, I can promise you we will be patient with you, and we ask that you be patient with us. They usually resolve very quickly, as we've already resolved the problem we had this morning with sound. So just hold still, and we'll contact you via email or phone if we have a problem during the course of the argument. All right?
Thank you.
Okay. All right, with that said, let me call the case formally. It's Commonwealth versus Patrick COWART, number 2020-0375. Attorney Dom, please begin your argument.
Thank you. Michelle Dane for Patrick COWART. May it please the court. I'll begin with issue 1 in my brief about the jury instruction on TR's capacity to consent in the case here. This jury instruction is given only when the evidence supports the finding that because of drugs or alcohol, a victim of a rape was so impaired as to be incapable of consenting to the intercourse. Simple and
I'm going to interrupt you for just 1 second, Attorney Dam. I'm sorry. I do hear a lot of feedback. Does anybody else hear that as well?
I do.
Okay. Perhaps I don't hear. Okay, so I see now Attorney Blatcher has his mute on. I think that might do it. Sorry for interrupting you. Please continue.
That's okay. Simple intoxication is not enough. The intoxication must be extreme before it can render a person incapable of consenting to sexual intercourse. In the vast majority of cases in Massachusetts, and in fact, all of the ones both published and unpublished that I was able to find in my research, when this issue arises, not only does the victim testify, but she testifies to either gaps in memory, loss of consciousness, or of having the physical inability to resist the sexual advances. For example, in Commonwealth versus Mountry, the victim testified that she woke up to the defendant putting on her pants and she had to ask him what he had done to her. In Commonwealth versus Jansen, the victim said that she had no memory of the sexual act with the defendant. In Commonwealth versus LeBlanc, the court found that based on the victim's testimony, that the jury could find that she had faded in and out of consciousness. The Commonwealth does correctly point out that I was not able to cite any authority saying that the victim must testify before this instruction can be given. However, they were equally unlikely to cite any authority saying that this instruction can be given in cases where the victim does not testify.
Attorney Dam, I'm going to interrupt you again. I apologize, but it seems as if that background noise keeps reoccurring. I can actually follow your argument, but I don't want you to be distracted by it while you're arguing.
I apologize. I think it's the heater in my office kicking on.
Oh, well, we need you to stay warm. So okay, so if that's what we think it is, then there's nothing we can do about it, and we'll listen to you even more carefully. Please continue. Thank you.
Thank you.
So if I could ask a question, why wasn't the testimony that she had consumed up to half a bottle of vodka, and along with the descriptions of her behavior by the various witnesses, both before and during the incident, sufficient to at least raise a question about whether she was able to consent?
Because the jury also heard lots of evidence about all the things that TR was able to do throughout that day.
Sure. So it's a jury question, isn't it?
I still think that there needed to be a little bit more specifically testimony from TR herself to kind of get what her state of mind was that day, whether or not she knew what was going on, whether or not she was agreeing to what was going on. I think in this case, to find that the instruction was warranted goes to Justice Spina's concerns that he had in Commonwealth versus Boucher, that a person who has sexual intercourse with someone who is highly intoxicated but still capable of interacting with others, which he said was a common occurrence, that those individuals will be accused of rape and that the Commonwealth will start trying rape cases like they do drunk driving cases in regards to alcohol and how that affects a person. Also, even if the jury instruction was warranted in this case, there was insufficient evidence that Mr. COWART knew or had reason to know that this made TR incapable of consenting. There are two things that the Commonwealth must prove beyond a reasonable doubt when their theory at trial is that the victim was incapable of consenting. And one of those things is that the defendant knew or should have known that her condition rendered her incapable of consenting. Mr. COWART here was not the one that supplied TR with any of the alcohol that she had consumed that day. He did not.
But he knew she was probably messed up.
He knew that she was probably messed up.
And he could observe the same things that the gentleman, perhaps it was AB, I forget his initials, who was there sitting on the log, could also observe about TR's behavior.
Yes. And it may have been reasonable for him to realize that she was under the influence of something, but that did not mean that it was reasonable for an 18-year-old kid to realize that that condition rendered her incapable of consenting to having sexual intercourse with him. Mr. COWART stated to the police that TR was the one that initiated the sexual encounter, that she took off her pants, and that she sat on top of him and was the one that initiated the intercourse. And AB, one of the Commonwealth's witnesses, actually corroborated part of that by saying that when she first came upon this, that she saw TR straddling Mr. COWART and bopping up and down. So I think the way that TR was behaving and the fact that she was initiating this intercourse, according to not only Mr. COWART, but to one of the Commonwealth's witnesses, that it wouldn't be reasonable for someone in Mr. COWART's position, an 18-year-old kid, to know that even though she may have been under the influence of something, that meant that legally she could not consent to having intercourse with him.
But isn't that exactly, I'm sorry. Go ahead.
Go ahead.
Isn't that exactly what Justice Sachs is pointing out? It was alluding to, which is the fact that that's really a jury question as to whether or not this defendant at his age, given the circumstances, would have known that TR was unable or in a situation where she could not consent.
I think, again, without TR testifying, I don't think that it was sufficient for them to be able to.
So what about a situation, for example, if the alleged victim is not at all available, death, unavailability, for whatever reason? Is your view then that you could never give this instruction unless the alleged victim actually testified?
There maybe would be a set of facts that would allow it, but again, in all of the cases right now in Massachusetts, it seems like, unless I missed a couple in my research, the victim has testified, and they testified to significant things showing that they were so extremely impaired that they could not consent. They testified that they don't remember parts of the encounter with the defendant. They testify that they felt that they were just physically unable to stop the rape from happening. Or again, they testify to either parts that they don't remember part of it, or that they actually physically lose consciousness and at some point woke up to what was happening. And I think it's very important when we're going off of not only someone's impairment, but what an individual is supposed to know from seeing that person and how they're communicating with someone, that it's very important to have the victim in these cases testify so we can get really into their state of mind. And maybe that person can remember exactly how much they drank that night, or can just testify to how they were feeling at the time that this intercourse took place, if they even remember it happening. And I think if it's a situation where they don't even remember the incident happening, then there's more of a reasonable basis to conclude that they were so impaired that they couldn't consent.
May I ask a couple of, go ahead.
Just could I follow up for 1 minute on the issue of awareness? What do you say about the testimony in the 3rd volume of the transcript to the effect that at least during part of the intercourse, when the defendant was seen having sex from behind with the victim, that she was limp and appeared unresponsive? At that point, what is the defendant's obligation?
That point, in the position that he was, I know there was testimony from someone that actually saw her face, that it looked like her eyes were shut. But there's no indication that Mr. Cowart, in the position that he was in, if he was behind her, would have actually been able to tell that her eyes were closed at that time, or that she may be actually being responsive. And again, someone witnessing a TR from that distance isn't going to be able to tell whether she's actually awake or not. That's where TR's testimony would have been very important, because we do know that as soon as staff came over, she was able to put on her pants, she was able to put her hair up in a ponytail, and she was able to run away from them and continue to evade staff from the school for a good amount of time. And the staff, I'm assuming, were completely sober. So all of those instances, again, I think shows that her testimony really was important in this case to really see what her state of mind was at the time.
I'd like to ask about a couple of the evidentiary issues you raised. First of all, with regard to the lay opinions, what rule of evidence do you contend was violated by allowing lay witnesses to say that based on her, the way she was acting, she was under the influence of something, but I don't know what?
That would be the, I think it's 702, which is a lay opinion testimony. It would have been perfectly reasonable for these witnesses to say that they believe she was under the influence of alcohol. I think the case law is pretty clear on that. But Commonwealth versus Gerhardt, when we got into OUIs and marijuana.
So tell me what part of 702? Or what principle? Even if I'm not asking you to quote 702.
Sorry. It's the principle that a person needs to have the experience in order to testify. There needs to be within the common experience of jurors in order for.
Okay. Well, could a lay witness say, not in this case, but in another case, I saw the defendant's eyes were glassy and bloodshot. I saw the defendant's speech was slurred. I saw the defendant kept losing his balance. He fell down and he lay there. I thought he was under the influence of something, but I didn't know what. Would that be permissible?
Their observations are, their opinion would not be.
Why?
Because to say that they're under the influence of something without actually indicating that it's alcohol, and potentially indicating that they have an opinion that that person could be under the influence of drugs, goes against what the court said in Commonwealth versus Gerhardt, that you need expert testimony, because it's not common knowledge how people are when they're under the influence of marijuana.
Sure, but Gerhardt says you can't say it's marijuana. Gerhardt doesn't seem to me to say you can't say it's under the influence of something without specifying what. I'm not sure I see what's more prejudicial about, in the hypothetical that I gave, saying the defendant was under the influence of something, but I don't know what, than it would be to say he was under the influence of alcohol.
And that may be for what Ms. McCormick testified to, but CM testified that it was his opinion that she was high on something other than alcohol. So while he didn't specify the drug that he believed that she was under the influence of, he did say that it was his opinion that it was, obviously, some sort of drug if it wasn't alcohol.
Okay. So what? Sorry, go ahead.
I would say I think his testimony was particularly damaging because his opinion about the signs that someone would have who was under the influence of drugs exactly mimicked how TR was behaving that day.
So what would be, why is it substantially more prejudicial than probative to say, I think she was under the influence of something other than alcohol based on these following observations of her behavior?
Because then we know that that person is offering an opinion that that individual was under the influence of drugs, which they cannot do unless they have expert experience and having qualified as an expert.
And Gerhardt is your strongest case for that?
Yes, that was the case that did say that in OUI cases.
You can't say marijuana.
You can't say marijuana unless the officer has been designated as an expert.
Right. On the medical records issue, what principle do you say, what rule of evidence do you say was violated by admitting the records saying alcohol poisoning and clinically intoxicated?
That would be principle. When documents are admitted and what's in those documents, again, is not common knowledge for the jurors to know, then you need expert testimony. So this is a similar situation where the diagnoses of clinically intoxicated, that she was clinically intoxicated and had alcohol poisoning, those terms aren't something that the common person would know, that a lay juror would know. There needs to be an expert there to explain what those two diagnoses made, how those doctors came to those decisions. Is it determined about how much a person drank? Is it determined about how much alcohol is in the bloodstream at the time that they're in the hospital? Is it determined by certain signs, behaviors that they're indicating? We simply don't know. And so in order for the jury to draw any sort of conclusions about what those diagnoses meant, they would have had to speculate as to what it meant and how the doctors came to their opinion that he was clinically intoxicated and had alcohol poisoning.
Are you saying it was substantially more prejudicial than probative?
No, I'm just saying that it wasn't relevant without expert testimony. If there are no further questions, I will rest on the brief.
Thank you very much. I'm going to check
you.
a moment with the panel, be sure that there's no further follow-up questions that either of my colleagues would like to pose. I see none. Thank you very much for your argument. We'll turn now to Assistant District Attorney Blatchford. And don't forget to take off your mute before you start your argument. There you go.
Howard Blatchford, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The central issue in this case clearly was whether the victim was so impaired as to be incapable of consenting to intercourse. And the Supreme Judicial Court was fairly clear, quite clear, in fact, in the Blacher case, that the instruction on capacity to consent should be given in any case where the evidence would support a finding that because of the consumption of drugs or alcohol, or for some other reason, lack of sleep, helplessness, and so forth, the complainant was so impaired as to be incapable of consenting to intercourse. No requirement that it be extreme intoxication, no requirement other than the fact that it must be such that the complainant was impaired as to be incapable of consenting. And the facts presented here from a variety of witnesses over a period of several hours all indicate that the victim was so impaired on the day that the rape occurred. Blacher pointed out 5 or so factors that they took into account in reaching the conclusion in that case that the victim was impaired. And those are: 1, impaired comprehension and confusion; 2, falling down and behaving combatively; 3, the victim was passed out for a period of time; 4, disorientation, loss of judgment, impaired perception and balance; and 5, exhibited signs of extreme intoxication. All of those factors were present in this case, and a variety of witnesses testified, beginning with Nicole McCormick, the teacher who was administering the MCAS test in the morning. She observed how this victim, who she knew from having been a teacher in several classes before, was out of sorts, was clearly not herself, how she fumbled with a computer, seemed confused, became confused again when she asked to use the restroom and went out the wrong door and then came back in, was confused again, and that she left behind a sheet of notes that was essentially incoherent and completely off topic. We heard testimony from a variety of witnesses that the victim was falling down as she came over the hill and down to the area known as the bridge where she was raped. She was stumbling. She was speaking incoherently about being chased by Indians and about the sky being purple. And when she got to the place where the defendant, along with Caleb, his classmate, was sitting on a log, she actually stumbled and fell. And both of them had to get up and retrieve her off the ground and bring her back to the log where they were sitting. Later, of course, after the rape, she escaped from the social worker from the high school who was there and found her, and ran up over the hill and down the other side, stumbling and falling continuously, and eventually made the very bad decision of running into a marsh. There was evidence that the victim was passed out for a period of time, and that came from really 2 or 3 sources. Ashley, who was a classmate who attended the science class with her after the MCAS exam, testified that she was dozing off. And at one point, she actually apparently did fall asleep because she hit her head on a table. And after the rape occurred, she testified that her eyes were blank and she appeared still intoxicated. Caleb gave a similar description of her being unresponsive and limp after the rape. With respect to disorientation, I won't go into all of the details on that.
Can I ask about the comment made, and this is switching subjects a little bit, but we were getting to that point in the narrative, about, I think, AB's comment on redirect examination. I later was under the realization that it wasn't just sex.
Right.
How would the jury have understood that?
I think the jury could not have understood it because it was completely vague and ambiguous and really out of context. If one were to go back and look at the transcript, it's involved.
What are some alternatives of what the jury, the defendant argues that the jury would have inferred that she thought it was rape. What other interpretations could the jury have put on it in your view?
I think that it's so vague and ambiguous that there's almost no interpretation that could be put on it. It's just words. The defense counsel at trial opened the door on this when at the end of cross-examination on page 87 on to 88 in volume 3, she asked the witness, and when you were in the woods observing the victim and the defendant having sex, you just thought it was the two of them having sex, right? And the witness replied at first, yes. Question, throughout your time in the woods, correct? Yes. Thank you. End of cross-examination. Immediately on redirect, the prosecutor picked up on that line of examination that the defendant's lawyer had opened. And she asked, you just indicated at first you thought it was just the victim and the defendant having sex. Yes. And later, what did you think? And then came, without any objections so far, by the way, and then came the answer. I later was under the realization that it wasn't just sex. I don't know what that means. I think that is statement that falls into the category of a fleeting comment that is so vague and ambiguous.
Do you think it's a plausible interpretation that AB meant I thought it was rape?
No, I don't believe it is. I don't believe it is. I think that it's too vague, too ambiguous, without any factual context. You would need a further explanation. And the prosecutor, there was a sidebar conference at that point in time, indicated that she was trying to draw out of the witness that that the victim was intoxicated, severely intoxicated at this point in time. That was the point. And the prosecutor decided not to go forward with it.
If that was the point, that would mean that she could not consent. And if she could not consent, then it would be classified as a rape, right?
Well, that's not a direct commentary on the defendant's guilt. So, but we never got to that point. The prosecutor decided to withdraw the question and everyone moved on. And I think without any additional context, it'd be unreasonable to attach any particular meaning to that particular comment. So going back.
Can I move to the issue of the prior consistent statement? In what way was the defendant accusing CC of recent fabrication such versus identifying some inconsistencies in her testimony, such that the comment about I testified before that it was half full was permissible?
I think, Your Honor, as we argued in the brief, that the cross-examination, the impeachment of this witness was fairly severe with respect to a number of issues. The length of time that they were at Mark's home.
Yes, it was severe, but was any of those suggesting recent fabrication? I read through them and I didn't see one that was. And some of the inconsistencies that were pointed out seem to be pointing to a prior version that was arguably more favorable to the Commonwealth than the version that was testified to that day.
I think that the cross-examination was so severe that a reasonable juror listening to that would think that the defense counsel is trying to show that this person is not a truthful witness, that she's making this up. And in those circumstances, even in the absence of a finding by the judge, it's permissible to ask a question to elicit a prior consistent statement once the witness finishes cross-examination. So the other side of this, of course, is that the witness never said anything on direct examination.
Well, but the judge asked her on cross. So I think that's a distinction without a difference. What's clear is that the defendant did not open the door by saying, by raising the issue, okay, exactly how much are you saying with your demonstration here? How much of the bottle did she drink? That was not elicited by the defendant.
Not on, well, actually what happened on cross-examination, as I recall, Your Honor, was that the defense counsel asked the witness how much alcohol was consumed. And she said about half the bottle. Now that she asked and answered that question. So she really did kind of open it up there. And then she went on to basically impeach this witness with respect to what she had just said. But I come back to the point that I think a reasonable juror could infer that that type of cross-examination was directed to show that this witness was making this up as she was going along. And in those circumstances, it was appropriate for the prosecutor to ask the question on redirect to elicit the prior consistent statement that she had given. Just going back to the indicia of impairment that was present in this case, and of which there was proof, the final item is under the Blanchet standards, they exhibited signs of extreme intoxication. And I point back to all of the things that I identified earlier. And particularly, of course, the witness, Ashley, observed the victim drinking the alcohol at Mark's home, which was only about 1 to 2 hours, depending upon how you calculate it, before the rape occurred. So I think that is perhaps the most telling evidence of that. But even without that, even if you subtracted that, we have the witnesses of all of the other people, the teacher at school, the social worker at school, Ashley, who observed her in the science class and after the rape, and Caleb, and the defendant himself, of course, told the police that she appeared to be messed up before the rape occurred. And he was there, by the way, and this goes really to issue 2, is did he know of her impairment, or should he have known? Well, he was there sitting in the log with Caleb, and Caleb testifies to all the observations that he made. And there are about 10 of them that appear on the transcript between pages 98 and 104 in volume 3, that she was coming down the hill, that she was talking incoherently, that she was stumbling, that she eventually fell, that her backpack fell off and out came a bottle of a beverage, which Caleb opened and smelled, and it smelled like alcohol. There were pill packs.
Of course, the defendant didn't smell it.
There's no testimony to that effect. That's correct. But the defendant was there, and it would be reasonable for a jury to infer that he saw what Caleb saw. He saw everything that Caleb saw. And he obviously saw something because he formed the opinion that she was messed up.
So that was one of the lay opinions that the defendant challenges, correct? Because
Correct.
He didn't say, he said it was, on something other than alcohol, didn't he?
I think the defendant said that. I believe that
well,
I don't have that.
we know that one of them, we've got
Yes.
3 lay opinions that don't say alcohol. We've got the teacher who says under the influence of something, perhaps under the influence of something, I don't know what. We've got one of the students who says under the influence of something, I don't know what. And we've got someone else who says under the influence of something, and she was high, not drunk. How is that? Why isn't that more substantially more prejudicial than probative when a witness is allowed to say, oh, I thought, in essence, I thought this person was under the influence of drugs, which is not something that a lay witness can say?
A couple points on that, Your Honor. First, lay opinion testimony concerning intoxication has long been admissible in Massachusetts because characteristics are so commonly known to people.
Sure, but the characteristics of being under the influence of various drugs are not so commonly known.
They may or may not be, and I would probably say that they're not as well known as the characteristics of being drunk on alcohol. But This is an area where I think this case doesn't really fall under the Gerhardt rule. And Gerhardt was a prosecution for operating under the influence of marijuana, where an element of that offense that had to be proven by the Commonwealth beyond a reasonable doubt was that marijuana was the intoxicating substance. We don't have to have here proof that the victim was intoxicated by alcohol.
Is that really true in Gerhardt? I mean, the OUI statute says alcohol, marijuana, any other intoxicant, or I forget what the words are, sedative substance. I mean, it basically refers to anything that's under 94C, or a few very broad categories under 94C. So, I mean, it seems to me that couldn't the Commonwealth prosecute someone for drunk driving without, or for operating under the influence of a prohibited substance without proving exactly what that substance was?
I think that would be a gap in the evidence, Your Honor. I think they would have to prove what it was the person was intoxicated by. Whereas here, there's no requirement that the intoxicating substance be established. It's simply that the victim was so intoxicated, or was by virtue of sleeplessness, stress, whatever. So
right.
unable.
But at least as instructed by the judge, the jury had to find intoxication.
Yes, that's true. That's correct.
By alcohol.
By alcohol. And there was substantial evidence here in this case from a variety of sources that she was in fact intoxicated by alcohol. And if there are no further questions, the Commonwealth would rest on its brief.
Okay, well, one moment, I'll check with the panel, and I don't see any further questions. I want to thank you both very much for the for your arguments. We'll take the case under advisement. And meanwhile, as we're still the pandemic, the panel wishes you to stay healthy and to take all precautions to stay safe. Okay.
Thank you, Your Honor.
About 20 seconds before we go live, and I'll introduce the panel and I'll call the case. Okay.
Thank you. Thank you.
You're welcome.
We're live.
Thank you very much, Angela. Well, okay, good morning and welcome to today's remote sitting of the Appeals Court. My name is Ariel Vuono, and I'm joined today by Justice Peter Sachs and Justice Catherine Hand. Two quick reminders before we begin your argument, and that is the rules that apply to oral argument, appellate argument in a courtroom apply also to a remote platform. So you each have 15 minutes to make your argument, and there is no rebuttal. Second, upon occasion, we experience a glitch or two in terms of the technology. If we do, they usually get resolved fairly quickly. Please be patient with us, and we will be patient with you. That said, I'm now going to call the second case on our list today, which is Commonwealth versus Brian HENRIQUEZ, 2019-0061. And Attorney Brennan, please begin your argument.
Thank you, Your Honor. Thank you. Please, the court. My name is Paul Brennan. I represent the defendant, Brian HENRIQUEZ. Before I take your questions, Your Honor, I would just like to make a few remarks. In this appeal, the defendant contends that his guilt or innocence was not fairly tried because the trial judge refused to give jury instructions on self-defense and necessity to which he was entitled, and also because defense counsel rendered ineffective assistance at trial because, first of all, he did not request the trial court judge to listen to the audio on the video that contained excited utterances that undermined the witnesses, the credibility of the witnesses for the Commonwealth, that is particularly Norberto Garcia. And also because the trial counsel for the defendant advised the defendant not to testify, notwithstanding that if he did not, basically the Commonwealth's witnesses were unopposed. There was no case to put in opposition to the Commonwealth's case. And if he had testified and with the assistance of the excited utterances on the video, he would have been able to put up a substantial defense. Now, I understand that advice not to testify does not have it's not have a stellar record on appeal in terms of ineffective assistance. However, in this particular case, given the fact that if he did not testify, There was no opposing, there was no evidence that the defendant could put in opposition to the Commonwealth's case. It was the only sensible advice that the defense counsel could have given at the time.
May I ask about the failure to testify? Assuming we find that defense counsel's advice was deficient there and that there's enough indication that the defendant would have testified absent that advice, do we then go on to evaluate whether there was prejudice from his failure to testify, or is that a kind of a structural?
Well, you know, it's, I have to admit that that's a question I had not anticipated. In terms of failure to advise a client or given defective advice to testify, I've not seen any case law saying that it's necessarily a structural error. However, it is, since the right to testify is a fundamental right, and if it has been found that the right to testify was not intelligently waived in this particular case, then I would say that that would be sufficient without requiring to find prejudice, without having to make a finding of prejudice. But I would submit that in this particular case, there's ample grounds for a finding of prejudice. What choice did he have in this instance? And the Commonwealth, by the way, does not contend that such advice was reasonable. The Commonwealth's argument appears to be that in his motion for new trial, the defendant did not aver that if he had been properly advised about his right to testify, and that he should have testified, that he would have done so. However, as I point out in my reply brief, that the defendant did submit 2 affidavits in support of his motion for new trial, and in his supplementary affidavit, he did aver that if he had been advised of his right to testify, and that it would be advisable for him to do so, then he would have insisted upon testifying. But he relied upon the advice of his counsel that everything was going great. But however, there was a trap that lay in waiting for him, and that is that the trial judge he refused to give instructions on self-defense and necessity. And in view of that,
there are a couple of principles that I thought governed here, and maybe you can explain why they don't, regarding giving of the self-defense instruction. One is that the right of self-defense ordinarily cannot be claimed by a person who provokes or initiates an assault. And that the original aggressor has no right of self-defense unless he or she withdraws from the conflict in good faith and announces his or her intention of abandoning the fight.
Well, okay. First of all, I want to stress that the defendant denies that he did what he's alleged to have done. In other words, the testimony of Norberto Garcia was false. However, since defense counsel decided to rely upon the actual testimony of Norberto Garcia in support of his motion for jury instructions on self-defense and necessity, the question is whether drawing all reasonable inferences in favor of the defendant, not the Commonwealth, but in favor of the defendant, whether he was entitled to such a defense. Now, true, the allegation was that he attempted to hit Norberto Garcia 3 times. Each time he threw a punch and he missed. But I would draw your attention to the fact that Norberto Garcia claims that he, in fact, after the defendant attempted to punch him or threw these errant punches, he struck Mr. Henriquez in the face and knocked him to the ground. And on the 3rd occasion, he picked Mr. Henriquez up and then threw him on the ground. Now, let's assume, for the sake of argument, that before that time that Norberto Garcia threw the defendant on the ground, he had the right to defend himself against Mr. Henriquez. However, when he did that, now we're into new territory.
So let's assume that that was excessive force, or let's assume that that was even deadly force, using the ground as a dangerous weapon.
Mm-hmm.
What case says that a defendant who initiated an assault regains a right or obtains a right to self-defense if the victim of the defendant's initial assault responds with excessive force or deadly
Well,
force.
Your Honor, I cited the case of Commonwealth versus Harrington, and there are cases that that follow from Commonwealth versus Harrington. But I would just point out that Commonwealth's argument appears to be that since Mr. Henriquez threw errant punches, then he is responsible for everything that followed, which I don't think makes any sense. In other words, because Mr. Henriquez threw errant punches, then he's responsible for the misconduct of Norberto Garcia. There are in effect two brawls here. There's the first instance where Mr. Henriquez allegedly throws 3 errant punches at Mr. Garcia. Mr. Garcia then throws him to the ground and then gets on top of him. Now, this is a new situation. We're no longer talking about what Mr. Henriquez did. We're now talking about what Norberto Garcia did. He had no right to arrest Mr. Henriquez. The testimony of Mr. Garcia was that he threw him to the ground and got on top of him and told him he was going to chain him until the police arrived. Now, Mr. Henriquez was not convicted of assault, simple assault, in connection with the 3 errant punches. He was convicted of assault and battery based upon what happened when Mr. Garcia was on top of him. And I would point out that the jury came back with a question about during their deliberations as to what was the law about assault and battery with or without, and just using their words, it was inartfully phrased, but they said, what was the law of assault and battery concerning, I'm sorry, the exact wording escapes me right now, but they basically had, they asked a question about the law of assault and battery and they used the term with or without consent. In other words, they were concerned that there was a brawl between these two people, and they felt that Mr. Garcia played a part in this. He had a role in this. And the trial judge then just simply repeated the instructions on assault and battery. And since those are the only instructions that the jury heard, and they did not hear any instructions about the right to self-defense, then of course they must feel that since the only testimony they heard came from Norberto Garcia, they must find the defendant guilty, because Mr. Garcia claimed that while the defendant was on the ground lying underneath him, Mr. Henriquez was scratching at him and biting him. And therefore, that would definitely constitute, if believed, that would definitely constitute assault and battery. So,
is there any evidence of when the defendant's alleged assault and battery on Garcia occurred relative to when Garcia started handling his gun?
Okay,
before or after?
Okay, as I understand the testimony at trial was that Mr. Garcia claimed that the defendant threw 3 punches at him, missed, and then Mr. Garcia picked him up and threw him on the ground, got on top of him, and it was while Mr. Henriquez was lying underneath Mr. Garcia that he was biting and scratching and so on.
Yeah.
And that, I assume, is what was the basis for the conviction for assault and battery. He was not convicted of assault. He wasn't charged with assault.
Right. So did that biting and scratching occur before Mr. Garcia started handling his gun, whether it was because it had fallen out of the holster or he took it out because he felt it coming out? Or
well, Mr. Garcia testified that and by the way, I have to say I found his testimony to be very vague and evasive on this point. But as I understand it, he claims that while Mr. Henriquez was on the ground, he was grabbing at stuff and feeling around his body. And at that point, he claims that he felt his gun coming out. And then he took out his gun, and he claims then that as he's taking out his gun, he's bringing it forward, the defendant grabs it, but Mr. Garcia then manages to put the gun on his sternum, and in his own words, he says that he
applied pressure
in order to inflict pain on him so that he would stop what he was doing, so he says.
May I interrupt? So the answer to Justice Sachs' question is that the assault and battery occurred, for which your client was convicted, occurred before that point.
Yes, I would assume so. Yes, but I would say but since he was subject to a false arrest, he was entitled to use reasonable self-defense. In other words, he did not the right to self-defense instructions where non-deadly force is used. It's where the defendant has reasonable concern for his safety, and he uses all reasonable means to avoid physical combat, and the degree of force was reasonable in the circumstances. Now, a person has a right to resist an unlawful arrest by, as I argue in my brief, by a private citizen.
Could I interrupt you? Was that an issue that was raised in the motion for new trial?
Yes, Your Honor, it was. Yeah.
Okay, can you point me to where?
I'm sorry, Your Honor?
Can you point me to where that was?
I'm sorry. I don't have the memorandum in front of me, but I did raise the question about the right to resist, Your Honor.
Okay.
Self-defense. He had no. Mr. Garcia was a security guard, which is something I did raise in the motion for new trial. He was a security guard, and security guard does not have the power of arrest.
Thank you.
And as far as I would also like to address the excited utterances.
Could I ask a question on that as well? Is it your position that the judge did not have available to him the trial judge did not have the original recording?
Well, the original recording was available to defense counsel. What happened was the assistant district attorney submitted a redacted video, which did not have the sound recording, and the assistant district attorney asked that it be played without the recording because she claimed that it contained statements by bystanders that were inadmissible hearsay. However, as I'm sure you've listened to it already, and that you will hear that there are people there accusing Mr. Garcia of pulling out his gun and pointing it at the head of Mr. HENRIQUEZ.
Do we know that those are firsthand accounts, the speakers on that recording? If I'm understanding correctly, the recording itself takes place after any of those observations would be made. Is there a way to link the speakers to the observations themselves?
But you can see, if you watch the video and you listen to the soundtrack, you can see there's a voice off camera, and you can see there are two. Unfortunately, you can't. At first, you cannot see everything that's going on, but what you do see is there are two legs outside, and people struggling, and then there's a voice off camera saying, he's saying, "This ain't right, brother. You're taking out guns and stuff, and there are people all around." And so this is relatively contemporaneous, and you can see this person is under the stress of. You can hear that this person is under the stress of the exciting event, and that and he's also saying, "This is all on video, man." You know, so in other words, he's saying to this, he's explaining that this is going to be seen by everybody, which speaks about the integrity of what he is saying.
Thank you.
Actually, your time has expired. I'm going to just check with the panel to see if they have additional questions for you. And I see they do not. I thank you for your argument. Those issues that you did not touch upon, of course, are not waived. We'll address them as they're raised in your brief. So I'll now turn to Attorney Calaflores.
Morning, and may it please the court, Joseph Calaflores for the Commonwealth. Let's start with the cell phone recording, just because that's where the prior discussion left off. When we're looking at the video, it's clear that the video starts many minutes after the start of the engagement. And the very first statement on it is, quote, "This shit ain't right, bro. What the fuck? This fucking N-word pulled indiscernible with people all around and shit." The quotations go on to get worse, and the Commonwealth would propose that the statements on the video is nothing more than a mere commentary of what is going on and adds nothing to the situation. At trial, there was no question of whether or not there was adjutant evidence. There was no real question of how the engagement started. It's really a question at trial of whether or not the defendant properly used self-defense or defense of necessity, which trial counsel pushed for instructions but was denied. So looking at the video, it shows a silent recording at trial, Exhibit 19, of the fight, and it doesn't really show anything. There's numerous allegations on appeal that the video should have shown something or should not have shown something. And one of those is whether or not it shows more of the fight and any of the injuries related to it. But the video doesn't really get into any close-up angles that would show any of those issues. The only relevance of the video is how the two were fighting and the placement. None of the commentary or any of the alleged additional video is present would be relevant at trial. Moving, I think, on to the more pertinent question on appeal is whether or not the defendant was entitled to self-defense and defense of necessity.
So I have a specific question about that.
Sure.
In a case called Commonwealth versus Naylor, 407 Mass 333 from 1990, there's a footnote 3 in which the SJC says that a defendant who provokes or initiates an assault might gain a right to self-defense if the victim responds by using excessive force or responds to non-deadly force by using deadly force. Naylor says that might be the case, but Naylor certainly doesn't decide the issue. Is there a subsequent case in which it's been determined that when a victim of an assault responds with excessive force or responds to non-deadly force by using deadly force, that the original assailant then has a right of self-defense?
Your Honor, I'm just looking briefly over my notes here. I'm not aware of any case that has expanded upon Naylor and held that certain facts, as in a case, did amount to that kind of switch in a situation. I would argue that this present case does not fit into any of those kinds of situations, at least as far as self-defense. When the initial kerfuffle happens, the defendant runs at Mr. Garcia and swings at him as Mr. Garcia is standing at the door. The second engagement, Mr. Garcia sees him coming in through a reflection of the window. So in both of these situations, the defendant is engaging with Mr. Garcia at the threshold of the bus terminal.
But the defendant says when Garcia throws him to the ground, he's using the ground as a dangerous weapon, and that's excessive force or potentially deadly force.
And that may be present in some applications of a person bringing another person down to the ground. I would argue here that Mr. Garcia is not really using the ground as a deadly weapon, but is really just in the midst of a struggle with a taller defendant. The defendant is about 6'1" or 6'2", and Mr. Garcia is about 5'7". So already at the start of the engagement, the defendant has presumably a longer reach as well as a height advantage over Mr. Garcia. So I would find it hard to believe that in this circumstance, the act of throwing Mr. HENRIQUEZ down to the ground would constitute an independent assault and battery, or even worse, an assault and battery with a dangerous weapon, the ground, that would constitute Mr. HENRIQUEZ to then properly use self-defense. When we're looking at self-defense, the prerequisites are that a reasonable concern for safety, that he used all means of avoiding combat, and the degree of force was reasonable. Now, all reasonable inferences given to the defendant, I don't believe that the defendant has met either a reasonable concern for safety or that he used all means of avoiding the combat. And that can be shown by him instigating both of the situations of coming at Mr. Garcia at the door, or continuing to fight when Mr. Garcia has the advantage and is on top of the defendant. He has used no opportunities to disengage from Mr. Garcia and has shown no reasonable concern for safety. There's no evidence that he tried to stop, that he did less when he was on the ground because of the disadvantage. Indeed, the testimony is that, and this comes from Mr. Garcia, Sergeant D'Ambrosia, and Officer Luna, as well as the two bus operators, that he continued to fight while he was on the ground. He never disengaged from the fight that he instigated.
Well, he was on the bottom, so it would have been hard for him to disengage, wouldn't it?
I wouldn't say it was hard for him to disengage. If the testimony is that he's reaching at the belt of Mr. Garcia and therefore the phone and the gun, and he's really just manhandling him, he can stop. He can take his hands, stop fighting, and just desist on the ground. He doesn't have to get up, remove Mr. Garcia, and step physically away. It could be desisting, I'm not doing anything. It could be words, I'm not fighting anymore, I'm done. Instead, if you look at the testimony, and the testimony of the witnesses, the gun comes out and the fight keeps on going. And I think that brings us to the defense of necessity. Now, defense of necessity has been expanded upon most recently as for a homeless person and historically more closely related to the possession of firearms. Now, I would turn the court's attention, and I've cited these in my brief, to Commonwealth, to Lockwood 95 Mass App Court 197, as well as Kendall 451 Mass 15. And in more specifically in Kendall, he must seek out legal alternative means. In Kendall, a defendant was held that a defendant must seek out alternatives prior to engaging in an OUI, where the only requirement is that he make a phone call, say, hey, can you pick me up, before he engages in driving that vehicle. Here, the defendant does not take any alternative actions before taking possession of this firearm. He does not ask for assistance from any bystanders. He does not exclaim about the gun. Indeed, when you're looking at the video, none of the bystanders come to his aid. He did not abate any of the danger when he attempted to take this firearm, and the Commonwealth would argue that there was no immediately placed danger. The firearm, according to the testimony of Mr. Garcia, was placed flat upon the chest. Now, there's testimony that Mr. Garcia pressure on the chest, but it's not clear how that pressure is placed on the chest. It's not clear.
But the barrel was pointing at the defendant's head, even if the gun was flat.
Mr. Garcia's testimony is that the barrel was pointed at his neck, but that he was placing it flat against the chest. So I presume it would look like something like this, if you can see my chest. And when that is happening, the Commonwealth would argue that there is no clear and present danger, because Mr. Garcia does not have a grip on the firearm. He is placing it flat against the chest. And this is after the firearm comes out loose from the grabbing of the defendant. This isn't a case where Mr. Garcia takes the firearm out and brings it around. It is coming already loose, and in an attempt to secure it, he brings it around and places it flat against the chest.
Well, let's say, I mean, the evidence of, I don't know, there is evidence whether Mr. Garcia had his finger on the trigger as he was pressing the gun flat on the chest. But let's say the jury believed that he could have, and that therefore the defendant did have some reasonable fear that he was about to get shot. Once the defendant gained control of the gun and turned it around and pointed it back at Mr. Garcia, what should the defendant have done?
Well, I guess I'd have to ask, at what point are we analyzing that claim? So he has possession of the gun. At the moment he has possession of the gun, and the case out there supports
Excuse
this.
me, when you say he, are you talking about Mr. Garcia, or are you talking about the defendant?
When Mr. Henriquez, the defendant, has taken the weapon as in possession of it, he has a duty to secure that weapon and get away from it. He doesn't have a right to take that possession and turn it around and use it. When we're looking at Commonwealth v. Power Coke on 69 Mass App Court 735, necessity is inapplicable when an individual remains instead of fleeing. And then to complement that, Commonwealth v. Ben B, 59 Mass App Court 919, a juvenile is not entitled to possess a firearm without seeking the assistance of the nearest police officer. In essence, you can't illegally possess a firearm under the defense necessity and then hold on to the firearm for 15 minutes, walking around before, hey, police officer, I have this firearm.
But that's
Here-
not really what happened here, because of course things happen so quickly, right?
Here, things do happen very quickly, but I would argue that the moment that Mr. Henriquez takes the firearm, possesses it, and we have a Johnny Pert saying that it is being held as if it was being gripped as a normal handgun. And the moment that he possesses it, turns around and points it and makes the statement, I'm going to shoot you with your own gun, I would argue that that is completely removing the defendant from the defense of necessity. It would be wildly different if Mr. Henriquez took the firearm and pushed it aside, or if he took the firearm and threw it away, or if he took the firearm and kept it behind his back as he struggled with Mr. Garcia. But here the facts show that Mr. Henriquez took possession of the firearm and utilized the firearm to threaten Mr. Garcia, which would take him necessarily out of the defense of necessity. It would not be a necessity to use the firearm and threaten. To possess it, yes, but to take that one step further removes himself from it.
May I ask a question before your time grows too short about the ineffective assistance claim relating to the erroneous advice about not testifying?
Certainly.
Your response to that in your brief is that, well, the defendant never clearly says in an affidavit that he would have testified. But I read his second affidavit at Record Appendix 283 to 284 as fairly clearly saying, if I'd been advised of the risk that the judge wouldn't instruct on necessity and self-defense, I would have insisted on testifying. So what is your argument about how there was no ineffective assistance other than that the defendant never claimed he would have testified?
Yes, Ron, I'm just reviewing that supplementary right now. With a defendant, without an evidentiary hearing, a judge is free to discard an affidavit as self-serving. Now, putting aside that cheat of throwing it away, the trial counsel explicitly said at trial, and this is at page volume 3 on page 22, that he was waiting for all of the evidence to come in, including both the Commonwealth and the defense evidence, before he advised and discussed with the defendant on whether or not to testify. Apologize, my light keeps turning off. It goes on for another 50 pages, and then at volume 3 at page 78, he does have a discussion with the defendant. I find it hard, without evidence otherwise, affidavit, documentary, or something to say otherwise, that trial counsel who waits for all of the entry of all evidence is somehow acting otherwise not rising to the level of normal effective counsel. And
the trial attorney declined to provide an affidavit. Wouldn't that suggest that there should have been a hearing on the motion?
Not in this particular application, Your Honor. There was a lot of other documentary evidence that was admitted, including emails back and forth from counsel. I'm not entirely sure that the absence alone of an affidavit from counsel would warrant an evidentiary hearing. Possibly combined with some of the other later issues, including whether or not there was a disclosure of where his wife worked. Possibly that may be, but once again, the absence of an affidavit itself is not warranting an evidentiary hearing.
The trial counsel did respond to that directly, albeit not under oath in an affidavit, but did respond to that issue directly, correct?
The issue of the wife?
Of conflict of interest, yes.
Yes, he did respond in an email stating, I have told the defendant that my wife worked at the Hendon District Attorney's office.
And as I recall, this was an appointed case, isn't that right, by CPCS? Or was it privately retained?
I believe it was appointed, but I'm not positive, and I don't have that fact in front of me, Your Honor.
I think so.
I see that my time has expired. If there are no further questions, the Commonwealth would rest on its brief.
All right, thank you very much. I don't see any further questions. Both of your arguments are very helpful. We appreciate it. We'll take the case under advisement. On behalf of the panel, we know that we're still under the strictures of this pandemic, and so we hope that you take all precautions to stay safe and stay healthy as we get through it. Okay.
Thank you, Your Honor.
We are live.
Thank you very much, and good morning, and welcome to today's remote sitting of the Appeals Court. My name is ARIEL Vuono, and I'm joined today by Justice Peter Sachs and by Justice Catherine Hand. Just two quick reminders before we begin today's argument. The same rules of oral argument apply on this remote platform as if we were in the courtroom. So you each have 15 minutes to make your arguments, and there is no rebuttal. Seeing as I recognize both of you of having appeared here before, I'm sure you already know those rules, and that you already know that we've read your briefs and the transcripts, and we're ready to hear your argument. The second quick reminder is that upon occasion, we have a technical glitch. If we do, that generally gets resolved very quickly. You'll be contacted by someone in the appeals court if need be. And in any event, we will be patient with you if that occurs, and we hope that you'll be patient with us. So that said, I'm going to call the third case on our list today, which is Commonwealth versus MALEK BOSMOND, case number 2020-0658, and ask you, Attorney Zendrowski, to begin your argument.
All right. Thank you. Good morning. May it please the court, my name is Matthew Zendrowski, and I'm here on behalf of MALEK BOSMOND. I'd like to focus on the first issue in my brief, whether Mr. BOSMOND possessed an operable firearm, whether the evidence was sufficient that Mr. BOSMOND possessed a firearm. So I argue that the evidence at trial was insufficient to draw an inference that the firearm that in Mr. BOSMOND's possession was operable, that it could fire. And so
I hate to ask the obvious question, but then how do you explain the fact that there was a wound and a bullet that was retrieved thereafter?
So I think that, I guess it would be a necessary implication. I think that then another firearm, I guess, made the wound, that it wasn't the gun in Mr. BOSMOND's possession. I think that's a necessary inference from my argument.
All right, but is it fair to say that that there was a stipulation that the other firearm that was recovered from the woods could not have been the firearm to have caused the wound or discharge that, or discharge the bullet that was retrieved from the victim's sweatpants, right?
Yes, there was a stipulation to that. That is fair to say.
All right.
And so, to the firearm in Mr. BOSMOND's possession, there's only one witness who had any descriptions of that. That was Mr. Simmons. His descriptions were rather fleeting. He says he saw Mr. BOSMOND reaching for the firearm, and then they were tussling for the gun. And then he never testifies that Mr. BOSMOND actually shot him with it. He is a passive voice. He was shot with the firearm. And so my best case for this argument is Commonwealth versus White, where the eyewitness there heard gunshots, and then after the gun battle died down, observed the defendant with the firearm, never saw them fire it. That firearm was recovered and tested in that case. That never happened here. And in that case, the SJC said that the defendant could not be convicted of the possession of a firearm unless they saw the defendant fire it and establish that it was capable of firing. And that didn't happen in this case. Other cases that support my position are Houseright, where the witness actually saw the defendant fire the firearm, saw the flash coming out of the muzzle. That didn't occur in this case. In the case of
that was also a case when the firearm was not recovered. Is that right?
Yes, the firearm was not recovered in Houseright. Yes. Another case where the firearm was recovered but not tested was Tewitt, where the defendant didn't actually fire the weapon, but they threatened the victim with the gun to some extent. and described the gun that was recovered as similar to the weapon that was threatening.
I had one other question with respect to your argument. I think it's pretty clear, but I just want to be sure that your only objection, or your only rather challenge to the sufficiency of the evidence has to do with whether or not this firearm was capable of discharging a bullet. There's no challenge to the length of the barrel or any other aspect of the firearm. Am I right about that?
Yeah, it is limited to the operability. The length of the barrel, no other aspect, just the operability of that firearm in question. There are no questions about that argument. I can move on to my second argument. Briefly, I argue that the Commonwealth made an improper closing argument when they argued that the firearm at issue was visible on the video surveillance that was introduced as an exhibit, Exhibit 17. And so I argue generally that there's no evidence that anyone identified a firearm in that video, that the facts of the fight are muddled, and so it wasn't a reasonable inference that at that point after the fight in the video that Mr. Bosmond was pointing with that firearm.
Am I correct that the prosecutor was actually showing the film at the same time that he was making the argument to the jury with respect to the whether or not the defendant was holding the firearm?
I believe so. I'm not entirely sure. I think that is the case.
I'll ask your brother that question.
Yes, he would know. And if there are no further questions, I can rest on my brief.
No, we read your brief carefully, and so I think we understand the issues. I'll just double check with my panelists. I see no further questions. Thank you very much. We'll turn now to you, Attorney Gagne.
Thank you very much, Your Honor. May it please the court, Stephen Gagne, on behalf of the Commonwealth. I was trial counsel in this case. With respect to the operability of the firearm argument, in this case, we had the victim himself saying that he saw his assailant reaching for a gun. The victim and a witness, Jessica Santana, both said that they heard a loud sound that was resembled a gunshot. Mr. Simmons sustained a gunshot wound to his leg, and the police recovered a spent projectile with damage consistent with having struck something or someone. Frankly, that constellation of factors is above and beyond what has been held sufficient in other cases. For example, in 3 cases that are cited either in my brief and or in the Nieves case, Commonwealth versus Fancy, as well as Commonwealth versus Tuitt, which my brother mentioned, and Commonwealth versus Stallions, those are all cases admittedly where the firearm was recovered, but they were not tested. And there were actually no shots fired from the firearms in any of those cases. So I'd suggest that the evidence was far more than sufficient to establish that the firearm Mr. Bosmond was convicted of carrying was actually not just capable of discharging, but actually had discharged a projectile in this case. Unless there are any questions on that issue.
No, not now. You can tell us why your closing argument was did not cross the any boundaries of improper argument.
Yes, Your Honor. I think the case law is a little unclear, I'd suggest. There are some cases such as the Lopes case and the Stote case, both of which my brother cite, in which the court describes there being a line and perhaps coming close to the line and sometimes crossing the line. I also cited the Wathy case in my record appendix. It's reproduced as an unpublished decision where a panel of this court, none of your honors, held that it was proper for the prosecutor to call the defense theory, quote, ridiculous. In the Lopes case, the prosecutor went much farther than that. He said it insults your intelligence. It's a farce of a defense and a distraction.
Well,
in that case,
saying the comment about he would say it wasn't a duck and it insults your intelligence seems to pretty clearly implicate the line in Stote, which says ridiculing the evidence of self-defense and saying it insults the jury's intelligence is an unnecessary characterization, comes very close to crossing the line of permissible comment on evidence developed at trial. And given that the choice between an unpublished decision of a panel of this court and a case decided by the SJC, I think we have to go with the SJC.
well, Your Honor, even if if Stote is controlling in this case, again, the prosecutor, I think, swung a little harder than I did in this case, where I think it was pretty obvious to the jury that I was engaging in some obvious rhetorical flourish talking about a duck walking into the courtroom. But in Stote, the prosecutor both called the defense ridiculous and saying that it insulted your intelligence. Notwithstanding that, the SJC said that it came very close to crossing the line. However, similar to in this case, there was no objection by trial counsel in Stote, which the courts recognize as some indication of whether or not it was truly objectionable at the time. And the court also went on to say that given the strength of the Commonwealth's case, it did not create any likelihood of a miscarriage of justice. Now, similarly, in this case, putting this in context, I think it was, and I say in my brief, I think it was an absurd argument. A fair one, but still, I think it was fair to say that this was an absurd argument, that where Mr. BOSMOND had a matching bite mark on his forearm, where the victim said he took as strong a bite as he could out of the person who shot him, where Mr. BOSMOND admitted that he was at the scene at the time, where his friend and co-defendant, Achille Brown, repeatedly identified.
But if the evidence is so strong, why do you have to ridicule it?
Your Honor, I just have to say it's difficult sometimes to not call a duck, and I think that it's fair when a defense or an argument is being raised that is just wholly contrary to the weight of the evidence, to call it what it is. Perhaps it was, admittedly, could have been said in a more restrained manner, perhaps a more artful manner, and perhaps it wasn't necessary to say insult your intelligence. It's certainly not something that you write down the night before and practice saying. Sometimes you do get caught up in the moment. But I don't think, for the factors I've outlined in my argument here today and in my brief, that it crossed the line that was referred to in Stote or Lopes. It was not objected to by defense counsel, and the court gave complete, albeit standard, instructions on the limited use of closing argument by the jury. Unless the court has any further questions on that issue or on the sufficiency argument, I would rest on my brief and ask you to affirm Mr. BOSMOND's conviction.
I did have a question about the other argument, the other challenge to your closing remarks, which had to do with the comments of the video depicting the defendant holding the gun.
Yes.
Was the video being played at that time during the closing? It appears to me it was, but the transcript is not always completely accurate in that regard.
Yes, Your Honor. I can't recall if I was playing the video itself and freezing it frame by frame, or if I was referring to the stills, which are reproduced in my supplemental record appendix.
Mm-hmm.
But yes, absolutely. The jury had the images on the screen when I was making that argument, and specifically rooting my argument in what they could see with their own eyes.
That's how it appears, and so thank you for that clarification.
Wouldn't it be better in this situation, instead of saying that's no finger, that's no glove, that's no cell phone, that's the firearm, to say, I suggest to you, members of the jury, that that's not a finger?
Well, Your Honor, I think that I'm not sure where you draw the line between almost anything you say in a closing argument is obviously being suggested to the jury. But I don't think that arguing to the jury that that is the firearm expresses personal belief. I'm not saying I've looked at this myself and in my opinion, that's a firearm. I'm referring them to the evidence. I'm pointing to the evidence to saying what I think the evidence shows, which is that that's the firearm. It's a reasonable inference.
Well, if you throw in the phrase, I suggest to you, every once in a while, it saves you a challenge on appeal at a minimum.
Point taken, Your Honor.
I have no further questions. I'm going to check with the panel to see if they have any further questions, and I see none. I want to thank you both very much for your argument. We'll take the case under advisement, get back to you as soon as we can. And before you sign off, on behalf of the panel, we all know that we're still under the strictures of a pandemic, and so we hope that you take all precautions to stay.
Good morning, member of the panels.
Good morning. Actually, one moment, please. I'm just going to call that's okay. Let me wait and check with our clerk to be sure that we are live. It's always a bit of a lag in between. So just hold on one second.
Yes, we are live now.
Great. Okay. Thank you very much. Good morning, Attorney Nissenbaum. Let me introduce myself and the panel too before you begin. My name is ARIEL Vuono, and the panel, my colleagues joining me today are Justice Peter Sachs and Justice Catherine Hand. This is case number 2020-0370. Attorney Nissenbaum, you're the only one appearing today. The appellee has not filed a brief or is arguing today. Just let me let you know that you have 15 minutes to present your argument to us. You can be assured that we've read everything that you provided to us, and so we're ready to hear your most salient points. Hopefully we won't have any glitches in the technology today, but if we do, just be patient with us and we'll be patient with you, okay? All right, please go ahead with your argument. Thank you.
Members of the panel, may it please the court, Wyckoff Nissenbaum on behalf of the appellant, ATTILA JAVOR. The appellant appeals the finding on July 16, 2019 of contempt based on three principal reasons. The first is the judge abused her discretion because there was no evidence offered by the appellee that would support the judge's finding. Two, the judge failed to comply with Rule 52, requiring the court to issue findings. And three, even if the court was somehow able to conclude there was sufficient evidence to support the appellee did not comply with the agreement, there was a good faith attempt by the appellant to comply with the agreement, which would preclude the court from finding a clear violation of the agreement, thereby preventing a contempt from being issued. Procedure, though, to talk about issue number 2, Rule 52.
May I just ask a threshold question before you get there, which is, as far as I can see, the judge didn't order any relief in connection with the contempt finding. So can you shed any light on what the father hopes to gain by this appeal?
Yes, so the case was bifurcated. The remaining issue, which still has not been scheduled for trial, is the removal. It was originally supposed to be heard on March 17th, 2020. That was the day COVID closed the courts. We do not have a new trial date. Unfortunately, we have another hearing in March where we hopefully get a trial date. So part of the removal standard is a good faith reason that he's not trying to prevent mother from having parenting time or affecting the mother's relationship with the child. So by the prior judge, which is now retired, finding him in contempt, it shows to this new judge that he was not communicating with the mother, allegedly, and this judge found that, or the prior judge found, there was some bad faith, clear violation of the agreement, which he says he did not do. I don't believe is supported in the evidence. So that's the reason why he's going forward with the appeal.
Thank you.
As far as Rule 52 goes, the Rule 52 states the court shall issue findings if this motion was filed. While the court issued detailed findings in the complaint for modification, as well as semi-detailed finding in father's complaint for contempt, the court only issued one paragraph of findings or statement, I would say in this case. It was a conclusatory statement regarding three reasons why the judge found in contempt, but there were no detailed findings. The language—
Did the judge ask for or permit the filing of proposed findings from either side on the contempt?
Yes, so we did submit proposed findings to the court. And the judge reviewed those, I would hope, and issued her findings on the modification and what I would consider detailed findings on the modification and on father's complaint for contempt, but chose not to on the contempt filed by the appellee. So the rules of civil procedure are nearly identical to the Rule 52 of the probate court, in part where it says that the court shall state after request, find the facts specially, and state separately its conclusions and law thereon. The Schrottman case, which I've identified in my brief, stated that it doesn't require extensive detail, but it does impose on the judge an independent duty to articulate the grounds of its decision. And in that case, it found that that alone was enough for a remand. And here I would argue that there were no specific findings, and it was just stated in generality. And the three reasons that she found in contempt are not supported by any specific findings. And I believe alone that should be enough for a remand. Unfortunately, in this case, the judge has since retired. And the subsequent judge, Judge Armstrong, which is no longer the judge assigned to this case, had indicated that she would not issue any specific findings because she was not the trial judge. So we did attempt prior to coming to court to get those specific findings issued. Additionally, I would argue that the contempt itself fails to state with any specificity the allegations. The evidence presented at the trial failed to state how the appellee met the condition precedent required in the agreement to try to mediate the case prior to filing the contempt. As far as the three reasons that the judge provided, I don't believe they were supported by or would be supported by any findings, or possibly findings of why father was in contempt.
May I just go back for 1 second to the issue of proposed findings? I looked through the docket sheet and I don't see any proposed findings docketed. And if they're in the record appendix, I must have overlooked them. Can you shed any light on that?
I will have to go back to the.
So the trial was in January of 2019, right?
Yes, I'm just looking for the. I can say we did submit proposed findings. We did submit a proposed judgment, some proposed conclusions of law. The judge had given us time, should be in the transcript at the end of the trial to submit those. I don't have the specific site off the top of my head. But
it wasn't docketed and it's not in the record appendix. Well, I don't want to take up all of your time.
I don't have that site right off.
Looking for that, yeah. But one other question about the evidence. If we were, I gather you're arguing that the findings of contempt were, among other things, clearly erroneous. But we don't have all the trial exhibits. As far as I can tell from the table of contents, we're missing exhibits 1 through 7. And then there were exhibits 18 and 19 introduced on the second day of trial that we also don't have. Wouldn't we need those to know all of the evidence the judge was looking at before deciding that her findings were clearly erroneous?
So I believe I don't believe she entered in any findings. So I don't believe that we can say they were erroneous or not erroneous because
she entered findings that, as you say, were brief and you characterized them as conclusory. But before we say that they were unsupported by the evidence, which you're asking us to do, we would need to have all the evidence in front of us, wouldn't we?
So the exhibits that we did include were the ones that were relevant to this part of the case. So she consolidated all the actions, the modification, both contempts. So we did what we thought was include an extensive appendix with everything relevant to this case. If my argument would be if the other side thought there were some documents that were not included, that would have been included in a supplemental or an appendix request by them. They were noticed on everything. They chose not to respond. But we did include the full transcript, which would indicate, I believe the ones we did not include were purely financial matters, but I would have to review those 1 through 7. As far as the 3, so she found failure to notify mother timely about the child's appointments, failed to provide her with names and contact information for some of the providers, and failed to confer with mother about the child's well-being or any decision he's making on behalf of the child. 1 and 2, I think, can be reviewed at the same time. And it was prior to primary physical custody changing in October of 2017. Mother was primarily responsible for scheduling all the appointments. At that point, they agreed in the modifications to change custody to father. But mother continued to have access to all the child's online doctor's portals where she would receive updates. And this was stated, testified to at the trial, and was also referenced in the parties' text messages. Additionally, it was testified that father had informed mother via text of these new appointments, and they had communications back and forth about appointments. Some of them were disagreements, but they were still communications nonetheless. And there was no testimony offered that father had changed providers and he was not telling mother or not disclosing. That's something that mother did not prosecute in her case at all. The third reason that the judge listed, I don't believe was supported by the evidence as well. From the time he got custody until the date of the judgment, there were really no major legal decisions or any legal decisions that he made without informing mother. The main legal decision that potentially could support was regarding the child's IEP and autism diagnosis. But throughout the relevant time period, the child remained in the Somerville schools. Mother continued to have access to the schools. The IEP, she received notice of that when all those appointments were. And then the doctors themselves, not father, was the one who changed the diagnosis that the child no longer had autism. So it wasn't something that he was actually advocating for or pushing for. It was just a regular routine appointment where the court, the doctor at that point said, hey, based on our review, we don't believe he has autism. So there wasn't a legal decision that he would have made that would have supported that conclusory statement by the court.
Can I ask you a question? I'm sorry, can I ask you a question about attendance to the teacher student conferences? Did I read in the emails that that your client indicated that he would not act as a supervisor, so to speak, for the mother of the child at those conferences? Now, could that have been reasonably something that the judge could relied on as not keeping in with the spirit of the agreement to notify her and enable her to attend these conferences?
So I believe that the spirit of the agreement is separate from the finding of a clear and unequivocal violation of a clear order. So I believe the order was clear, but there were many orders, temporary orders at that time period dealing with who the supervisors were, who they weren't, what mother was allowed to do, what she wasn't allowed to do. And from the findings, you can see that mother was unraveling at this time or spiraling. Father did not, instead to her, I'm not going to be the supervisor. We don't agree. And I don't think that him saying, I'm not going to be the supervisor is preventing her from
attending
appointments. She could have attended over the phone. It wasn't his job to advocate for her. It was never in the agreement that they had to arrange it so they could both be available. They just had to inform each other and notify each other of these appointments, and he did do that. And previously, she had the ability to reach out to the school directly, and she still had the ability to reach out to the school. So I don't believe he even violated the spirit. I believe he followed the spirit, and he actually followed the agreement to a T, because he did communicate. She knew about it, and there was no obligation that said he had to only conduct these meetings if she was available to be there in person. There were alternative ways for her to attend, not to advocate for herself, and potentially it was based on her state of mind at that period of time. Going back, I guess that leads to the final argument. There were text messages back and forth where he indicates there's been a lot of changes to this. I've spoken with my attorney. This is the temporary order. There was one appointment where he rescheduled it to a date after a hearing so we could get the judge's input at that hearing. So he never at any time intentionally tried to prevent her from being part of the appointments. It was his job to comply with the orders. The guardians themselves assumed certain things of the orders, and it resulted in them being removed as the guardians. So my client, knowing that, wanted to say, this is the order, this judge takes orders seriously. I'm going to stick to these orders. And if there's any confusion, we can request the judge to clarify. And I think that's a reasonable position to take.
Well, one final question.
Yes, sir.
The successor judge said she wasn't able to make detailed findings because she didn't preside over the trial. In theory, couldn't we, if we thought that the findings were unsupported or we couldn't review them because they weren't sufficiently specific, couldn't we essentially vacate the contempt finding but allow for a new trial on the contempt complaint, rather than, as I think you're suggesting, basically ordering the contempt complaint dismissed or otherwise closing it out in some way?
Yes, I would agree. There will be a second hearing. So if she wants to, I think that would be appropriate. I don't believe.
And she can raise those issues either as contempt or in opposition to the removal request, or both.
Yes, I think that they could be relitigated at the second part of this trial, which will hopefully happen shortly.
Thank you.
Okay, I see no further questions and your time is up. Thank you very much for your argument. Take the case under advisement, get back to you as soon as we possibly can. Meanwhile, we, on behalf of the panel, we hope you and your families stay safe and stay healthy during the pandemic. And we will get
We are live.
Thank you very much. All right, good morning and welcome to today's remote sitting of the Appeals Court. My name is ARIEL. I'm joined today by my colleagues, Justice Peter Sachs and Justice Catherine Hand. Just two quick reminders before we begin, and that is the rules regarding oral argument in a courtroom apply to the remote platform as well. You each have 15 minutes to make your argument, and there is no rebuttal in the Appeals Court. Second, upon occasion, we do have a couple of glitches in this. I guess I'll call it again in this remote sitting. If that happens, please be patient with us. We'll be patient with you. They generally get resolved fairly quickly, it should not be a problem. If it does happen, of course, you will not lose any of your time during the course of your argument. With that, I'm going to call to the next case on our list, which is number 2020-0151, Haley Limited Family Partnership versus Town of Milton. Attorney Curhan, you may begin your argument.
Good morning. May it please the court, Dana Curhan for Cali Limited Partnership. In this case, the town of Milton for a number of years assessed the plaintiff for lot 33 as if it was a buildable lot. By way of background, Mr. Adams or the partnership acquired 3 lots adjacent to his own property. A couple of them were combined into lot 34, which was a buildable lot and which was sold. Lot 14 was my client's residence, and lot 33 was an unbuildable lot adjacent to lot 14, which ultimately merged with lot 14. Adams and/or the trust paid the property taxes on lot 14. However, he received separate bills for lot 33, which he regrettably ignored. Not the advice I would have given him, but that's what he did. I think he thought that it was for part of lot 33, and he so testified, or lot 34, and he thought he was being assessed either an excessive amount if it was the little piece that was lot 33, or that he was being assessed for somebody else's property. And the judge noted at Record Appendix 92 that he believed that they possibly belonged to another parcel. So he first acted after learning that his mortgage company had paid the taxes on lot 33 and were now assessing them to him with interest. We contend that, as we did a trial, that the town ultimately collected a substantially larger amount than they were due for lot 33, that this was largely a mistake by the town. Again, he should have been way more diligent and acted within the time period for filing an abatement, but we contend that this was one of those unusual cases where, because of the substantial windfall that the town received, and because this was largely their mistake, an equitable complaint, complaint in equity, which was filed, is an appropriate mechanism for addressing this. Again, it's not a simple disagreement over the fair market value of the land at issue, but a fundamental mistake compounded over the course of several years by the town in assessing taxes that they contended were due on the land.
But it was an issue that was confined to this lot, correct? Unlike this Bettigol case, or Bettigoli, I'm not sure how to pronounce it, versus Assessors of Springfield, where there was a challenge to the entire assessment methodology used by the municipality. We don't have any information that this was being done elsewhere in the town, so I think I would agree. I think tax collector versus tax collector of Braintree may be more appropriate, where it's sort of it applies just to him, but there was sort of unique circumstances here. If he just owned lot 33 and didn't own lot 14 and, you know, couldn't ignore it, that would be probably be a different story. But again, he was paying the taxes on lot 14 in his residence, and he, I think, reasonably believed that he was properly paying his taxes. You know, I think the first judge who heard this case on a motion to dismiss said that it's not clear, it's unclear whether the administrative remedy under Chapter 59 is seriously inadequate. I think that really is the crux of it, and I think the judge, after hearing the evidence, I don't think he necessarily found the facts against my client. I mean, he found that he was less than diligent in not seeking an abatement, but he essentially ruled as a matter of law that that the only remedy in this case was an abatement, and we disagree with that. We contend that in the unique circumstances of this case, that equitable remedies should have been available, and that's what we're requesting.
But Mr. Curhan, what is the inadequacy, other than the sort of heartbreaking quality to your client of the outcome of the administrative remedy available to him?
Well, the inadequacy is that he didn't realize that there was a problem because he was paying the taxes on lot 14, and he
But
believed
he
that.
received, at least in some cases, I'm sorry to interrupt you. I apologize.
I'm sorry?
I cut you off and I didn't mean to. I apologize.
He was paying the taxes on lot 14. And I think he reasonably believed, which ultimately happened, that lot 33 and lot 14 merged. So
At least some of those bills that he was receiving or that the partnership was receiving were for separate lots. Is that there isn't a contest about receipt of the tax bills, correct?
there's no question that he received the tax bills. The judge found that he received them and he didn't pay them. And he testified that he went down to City Hall, Town Hall at some point and said, "Hey, what's the problem here? You need to fix it." And the guy said, "Yeah, I'll fix it." Now, the judge didn't make any findings on that. So I'm not sure how much that helps us, but I think it does help us that the town seems to have made a pretty serious mistake and collected in excess of what they were entitled to. And that's really a problem in the way it was handled all around. And this was nobody's finest moment here. Unless there are any further questions, I'll submit the remaining points on the briefs.
I'll check with the panel. One moment, and I see no additional questions. And so thank you very much for your argument. We'll hear now from Attorney Freitag.
Thank you, Your Honor. Kevin Freitag on behalf of the town of Milton. May it please the court. Your Honors, this is a disputed valuation case. The appellant here believes that the property taxes on lot 33 were excessive. And if that is his position, which it is throughout his brief, then the very straightforward relief for that particular claim is to have sought abatement of the taxes at the time that they were issued. They would have been paid, and then an abatement would have been filed with the assessors. That didn't happen here. Inexplicably, it didn't happen here. The appellant has never taken the position that he didn't receive the bills. In fact, just the opposite. He received all the bills. He discarded the bills. Although he has taken the position that he thought that they were for some other lot or perhaps were in some way excessive. I think it's important to keep in mind that these lots were all created by the appellant. He was subdividing and moving parcels around. And so it doesn't seem to me that it would have been any great surprise to him that he was receiving bills for parcels that he owned that were all part of this sort of situation regarding the subdivision and the buying and selling of these lots back and forth between Mr. Adams and the partnership. In any event, the bills were sent out. They were not paid for many years, over 10 years in some instances. From 2002 up to 2012, tax bills were sent out, not paid. And then in 2014, Mr. Adams decided to file an action in the Superior Court. And that, in doing so, completely subverts the entire administrative process that is set forth in Chapter 59 of the General Laws. An incredibly robust process that includes a quasi-judicial board, the Appellate Tax Board, which is uniquely suited to determine whether or not property is being over or I suppose undervalued by assessors. And so in doing so, that entire process has been sidestepped. And while the case law in the Commonwealth suggests in sort of strange fashion that while the administrative process set forth in Chapter 59 is the exclusive remedy, that apparently exclusive doesn't always mean exclusive, and there are some exceptions to that. But the exceptions are only there if there's the existence of some serious inadequacy in the administrative process. And I think that that's something that is completely lacking in this case, despite the fact that the appellant baldly asserts in his brief that there is some inadequacy to the abatement procedure. There is no factual underpinning to that claim whatsoever. The appellant simply just got the bills and didn't file, period. So I don't think that the appellant is in any position to argue that there's any inadequacy, let alone serious inadequacy, in the administrative process that was available. But even setting that aside, the court might look to provide some equitable relief in this case, had there been some showing of novel questions of law or some public interest. And Justice Sachs cited the Betegol case, which is in both of our briefs. That is a case where the court did, upon receiving a complaint for a declaratory judgment by, I believe, over 10 taxpayers seeking injunctive relief about a tax that was going to be imposed based on a citywide valuation system that did not conform with the law or the Constitution of the Commonwealth. The court said, all right, here's a situation where an equitable remedy is available and is suitable. But that is a far cry of great distinction from the facts in this case, where we have one individual who disputes the value of his property. And I think it's worth noting that no one disputes that lot 33 had some taxable value. In other words, the taxes on that property were not void. The appellant is not arguing that. If he was, then there would be a different course of action here. He could have paid the taxes and then brought an action under a separate section of 59, or could be making a different argument today to this panel, but the appellant isn't. The appellant is saying it wasn't a buildable lot, and as a result, the town had it valued for greater than it actually should have been valued. One parcel, one appellant, no novel questions of law, no constitutional issues. This is a unique claim by a unique party, and it should have been resolved by way of an abatement, and it simply wasn't. And so while the appellant makes his claims here today in good faith, I would suggest to the court that there is simply no grounds to grant this appellant any relief. The Superior Court got it right. And upon that, I really would just rest on the points in my brief, and I'm happy to answer any other questions that you may have.
Can I ask one question, and I'm not sure it has any determinative value, but when did the town make the first efforts other than billing for the taxes to collect on the unpaid taxes?
I'm not sure that there was an effort by the town. I think that the taxes were leaned against the property, and that was, I think, picked up by either the appellant or the appellant's bank when he went to either sell or refinance the property. And then at that point, I believe, and I would defer to my brother on this, but I believe at that point, the bank stepped in, paid off the taxes, and sent the bill to the appellant. And that's when this whole issue came to the fore.
Thank you.
Would it make any difference? Another question I have is, would it make any difference if, for example, the lot 33 was grossly, excessively overvalued? Would that make any difference in terms of the equitable aspect of this argument? And let's say that had been shown that for some reason the tax was, was valued at $1 million or something like that.
Right. I think that that's an excellent question, and I think that the answer is yes. I think that at some point in time, if it would seem that the court should take notice of that. I would point to two things, though. This appellant has never shown what the delta is, has never even suggested what the delta is between what the valuation was and what it should have been. And so while the brief says something to the effect, the appellant's brief says something to the effect that it shocks the conscience, I find that to be completely unsupported by the record in front of this panel. In other words, that lot 33 had value without a question. The question is, what should its value have been? And the appellant has never undertaken to even make an argument as to what that difference should have been. In other words, how many more dollars in taxes he paid as a result of some mistaken evaluation. And I would suggest to the court that that question also illustrates exactly why this administrative process, which has a definite time period attached to it, is so important, not only to the town, which relies on on its tax revenue in order to set its budgets on an annual basis, but also to courts like the Superior Court, who was in some part being asked in 2014 and in the years thereafter, while this case proceeded in the Superior Court, to consider some difference of valuation on a parcel in Milton from 14 years before, as opposed to the ordinary process where you'd pay your taxes, file an abatement, there's a short period of time, it goes to the assessors, and then the assessors and the ATB are much better equipped to actually make a determination about what the appropriate valuation of the property should be, as opposed to 12 years later in the Superior Court with, however many years it is, maybe it's 8 years, fiscal years that are being disputed. It puts the Superior Court in sort of an impossible position that it really never should have been in the first place had the appellant just filed the abatement like anyone else could have. And people do this all the time.
Okay. I have no further questions. I'll check with the panel to see if they have any additional questions. I don't see any. So I thank you both very much for your arguments. We'll take the case under advisement, get an answer to you as soon as we possibly can. I'll just conclude by saying that we all know we're under the stricture still of a pandemic, so we hope everyone stays safe.
We are live.
Okay, so if you could both just hang on for one moment, I want to call the case and introduce the panel to you and give you two quick reminders. So this is our final case on for argument today, 2020-0119, Jason Leavitt versus KERRY RESTUCCIA. For those of you who are watching on YouTube, you will see that you will only be hearing the voice of one of the attorneys in this case. That's the attorney that represents Mr. Leavitt. And you will still be able to see the attorney representing the other party in this case, which is KERRY RESTUCCIA. So let me also welcome you to the remote sitting today. My name is ARIEL Vuono. I'm joined today by my two colleagues, Justice Peter Sachs and Justice Catherine Hand. You each have 15 minutes to present your argument. The rules and with respect to this remote platform are exactly the same as they are as if we were in the courtroom. And the only other thing I want to remind you of is we do upon occasion have some technical glitches. Please be patient with us if that happens. We'll be patient with you. They generally get resolved fairly quickly. Attorney Madden, I'm going to ask you to begin your argument in a moment. I will be able to watch the time, and I'll give you a heads up when you get to the 10-minute mark, and then I'll let you know when your time is up, okay?
Thank you.
All right, so Attorney Madden, you may begin your argument.
Good morning, Your Honors, and may it please the court, Terry Madden for the plaintiff appellant Jason Leavitt. And for the sake of clarity, I will refer to him as father and the defendant appellee KERRY RESTUCCIA as the mother. And before I begin, I want to just thank you for accommodating my computer difficulties. And that being said, I'll focus specifically on the issues pertaining to the calculation of an appropriate child support order in accordance with the guidelines, and in addition to an equitable credit that was requested against the established DOR arrears for monies that the mother had received by way of an accumulation of dependency benefits, in addition to the child support order difference between what the father has paid per week in support and what he should have been paying had the child support guidelines been properly calculated.
What would, excuse me, Ms. Madden, if I may ask just at the outset, what would the difference have been between what the father was paying since the time he began receiving the SSDI benefits and what you say would have been the proper amount if those SSDI dependency benefits had been included in father's income and then treated as a credit against the guidelines amount that he would have to pay?
Okay, well, as of the first complaint that was filed, which was August 25th, 2014, had the child support guidelines been properly applied, he would have paid $40 per week, less the application or the deduction of the dependency benefits. At the time, I'm not quite certain what they were. I believe it's in my brief, but I think it was approximately maybe $90 a month. So it would have been $40 less the dependency care benefits that the mother was receiving.
You mean
At the
40
time,
minus 90?
No, it would have been 90 divided by, so $90 per month.
Divided by 4.
Yes.
I see. So
At the time,
40
he was
minus
paying
2250.
approximately, yes. Yes, so that would have been the proper amount of child support had the guidelines been applied. No action was taken at that time. He was paying then $90 per week plus an additional $10 toward arrears, which he continued to pay through June of 2016, when the support order was actually increased to $117 a week plus an additional $20 a week towards arrears. So had the child support guidelines been applied back in 2014, naturally the support order, the weekly support order would have been substantially less than what he continued to pay, which actually increased 2 years later.
So, and I'm sorry, the amount he was paying as of 8/25/14 was what?
Was $90 per week plus an additional $10 towards arrears. And that was deducted directly from his SSDI and paid to mother through DOR.
So could you tell, I'm sorry to interrupt, but so basically the gross amount that you're saying should have been applied towards the arrears as an equitable amount is $22.50 per week from the year, starting from the year 2014.
Yes, which is actually increased. The amount of the dependency benefits that the mother receives now has increased to, I believe it's about $190. So it is now
about $39 a week.
It's $43.85 per week is what the mother receives in addition to the child support.
Is there a place where you've given us an exact amount that you think that the judge should have applied equitably in the record?
I did. I detailed the figures towards the end of my brief, which would have been starting, I believe, on page 46. But I broke everything down in terms of each complaint for modification that the father filed and compared that to what the mother is receiving in dependency benefits in addition to what the father's SSDI income was. So in addition to the retroactive calculation of a child support order, we would also ask that the dependency benefits that the mother receives obviously be credited toward an appropriate child support order. And again, at this point, it's $43.85. At the time of trial, it was $39.60 per week. And unfortunately, the trial judge mistakenly applied this figure to the mother's income as opposed to crediting the child support order with the dependency benefits. And if you at addendum 76 at footnote 1, the child support guidelines defines the income definition and how the SSDI and dependency benefits are supposed to be applied towards a child support order. Finally,
sorry, I understand that you're looking for both prospective relief in terms of recalculating in accordance with that footnote 1 you just referenced, and some kind of retrospective relief. I'm not clear about the difference between the equitable credit against the arrears that you're looking for and the retroactive order that you're looking for.
Well, it's twofold, and that's the third argument that I would like to make to the court. On the one hand, it's the total amount of dependency benefits that the mother has been receiving since she's been receiving it since 2013, although father didn't file his first complaint for modification until August 25th, 2014. So it would be from that point forward. And I believe the total amount I put in the conclusion and request for relief in my brief amounted to $14,119 that the mother has received in dependency benefits over and above the child support since 2014. In addition, I calculated the retroactive child support order, the difference between what the father should have been paying and what he continued to pay, which amounted to $13,535. The difficulty is that the father Social Security title allows for only a certain amount to be deducted from the father's Social Security disability income. And the difference is roughly about $100 every month. So that amount continues to be applied as arrears against the father. And of course, you have interest and penalties that continue to accrue in addition to the ongoing accumulation of arrears.
And so why did the judge decline to enter this retroactive order?
Well, I don't know. There were no specific findings that the judge made in terms of the deviation from the child support guidelines. There's nothing in his decision that supports his decision to deviate from the child support guidelines other than the fact that he opined that the father's Social Security disability income is not income, and that the father is capable of working a full-time job. Of course, that is a contradiction to the Social Security Administration's determination that the father is in fact disabled. And it's also contrary to, for example, Rosenberg v. Meridia, where the court acknowledged that it was the Social Security Administration that determined the father in that case had been disabled.
Well, I didn't see in Rosenberg, and I don't know what principle would say that the Social Security Administration's determination of disability necessarily has collateral estoppel effect in a dispute between parents. Can you point us to something that says so?
Well, I know that on in Rosenberg on page 184, it does recognize that the Social Security Administration did determine that the father was disabled. And I would suggest that that suffices. To do otherwise would impose upon the trial court or the family court to make that determination, a medical determination as to whether or not one party or the other is medically disabled or physically disabled. I don't think that that's an appropriate burden to put on the court in the first place. And in the second place, it puts an undue burden on mothers and fathers to not only prove their case, but prove their disability, which they've already had to do with the Social Security Administration.
Well, I think that in the probate and family court that happens often, that people have to come in and show what they're capable of earning or not. But my follow-up question with respect to this is, let's say we were to disagree with you and that we do not think that the determination by the Social Security Administration is the final word here, that the judge can make that determination in terms of attributing income to your client. How can we evaluate that if we don't have a transcript? In other words, how can we evaluate whether or not the judge abuses discretion or made findings that were clearly erroneous with respect to the attribution of income without having a transcript?
Well, I would have to agree to you. And as I explained in my reply brief, I made every opportunity. And again, I reside out of state, so it's not feasible for me to just go to the court and try to follow up on why the transcripts aren't being gathered. I did make requests. I did submit an affidavit of indigency that was denied. I think I put in my reply brief that after it was denied, there was a hearing date that was scheduled for the following week. It was completely impossible for me to fly into Massachusetts to attend that hearing, and I wasn't even made aware of it until a few days before it was set to go forward in any event. I did make many
Would you have to
to
attend in person to that at that point?
Well, I did try to reach out to the court. I reached out to the registrar's office. I reached out to the judge's lobby. I left messages. I tried to make some other accommodations. Unfortunately, I never received a response to my efforts.
Well, you would agree then, I think what I'm hearing you say is that you would agree that we're not in a position to be able to resolve that if we don't have the transcript.
That's no, what I'm saying is that I believe that there's enough on the record, and there's certainly enough in terms of what's been filed to establish the fact that the father's income is the Social Security income, and that the guidelines allow for Social Security income to represent what one party or the other's income is. And that in and of itself is sufficient to render a decision and apply the child support guidelines in terms of each party's income.
Attorney Mann, I want to say that I said that I would watch the clock, and I'm afraid that I got carried away myself with the argument, and you only have just under 3 minutes left in terms of what's your estimated time, okay? Your allotted time, rather.
Okay. Well, I will leave the rest of my argument. I'll rely on my brief and my reply brief, except to say that it would be difficult for the judge to be in a position to determine the father's ability to earn an income over and above his Social Security disability. To say that he should have provided medical documentation to establish what the Social Security Administration already established puts him in an unfortunate and almost impossible situation to sort of prove his disability twice. Beyond that, it's never been disputed. The record is clear. The mother has always acknowledged the father's disability. I think the dispute always became that he should work in addition to what he receives in disability. And I will reiterate that the father...
individuals who are receiving SSDI do in fact have the opportunity to work in some cases. Is that right?
Yes, that would be the right to work. And again, that was detailed a little bit further in my brief, but it's more of, it's an opportunity for them to be retrained. And the father has consistently over the years attempted to gain employment. And the difficulty is he has been unable to maintain that employment due specifically to the traumatic brain injury he suffered because he simply cannot remember. And that has constantly interfered with his ability to perform any of his employment duties and has always resulted in him losing a job. It's not that he hasn't tried, it's just that he's physically or neurologically incapable of maintaining full-time employment.
Okay. You're down to under a minute now. Is there anything else that you want to tell us before your time expires?
No, I thank the court for its time and courtesy.
Okay, I've just checked to see if the panel has any additional questions, and I see none. Okay, thank you very much, Attorney Madden. We appreciate your joining us by phone today. I'm now going to turn to Attorney Lowley.
Good afternoon, Your Honors, and may it please the court. The appellant's argument here has a fatal flaw. There's no record of the transcript. We had all the parties testify. Counsel had the ability to call witnesses. She did not beyond her own, beyond the father. The record presented by the appellant is not complete according to Rule 18 and the other rules I cited in my brief. She did not produce the transcript, so I don't know how the court could say the judge made a clear error of law or abused his discretion here.
Well, isn't there, aside from evidentiary issues, isn't there a purely legal issue here presented about whether the SSDI dependency benefits should have been treated as income to the father rather than the mother? And as I read your brief at page 20, you seem to agree that you cited the Rosenberg case and the guidelines footnote, that it's supposed to be credited to the non-custodial spouse and then, I'm sorry, treated as income to the non-custodial spouse and then given as a credit against the guidelines amount of child support that the non-custodial spouse owes. Why isn't that something that we could say, hey, the judge didn't do that, didn't explain why, despite the issue having been squarely raised, and we should send it back at a minimum to fix that issue prospectively?
Well, Your Honor, a few other spurious and confounding variables enter into the equation. First of all, mother has been caring for this child 100% of the time. The guidelines allow for deviations to account for that. When these guidelines were run, it was assumed that father would have the child 33% of the time and mother would have 66% of the time. Deviations, according to the child support guidelines, are allowed to be made to account for that as well. So we suggest that if there is an exact match on how things are calculated, first of all, we don't have any evidence of how the judge did calculate those guidelines, but it would be very close if you did it correctly according to the Rosenberg v. Merida standard and flipped it to allow mother to claim 30% of the time the father hasn't been caring for the child. Father hasn't seen the child in 7 years. Mother, this is solely rests on mother. She's paid for all the extracurricular activities, all the medical, uninsured medicals. She paid for insurance while she was working. She drives her.
Well, it may or may not be.
And I would suggest to the court that not only that factor, but also the factor that there was attribution of income here. So that entered in the picture as well. And I thought it was a very fair attribution of income, despite hurting my client, because father actually earned $19,000 in 2017. When he appeared before the court earlier, he told the judge that he worked for Uber and Lyft. He was earning income. There's no doubt he was earning income. Subpart G of the Social Security Act allows people to get tickets to work.
But the amount that someone earns or that is attributed to the father here doesn't affect whether it's proper or not to attribute the dependency benefit as income to him, does it?
It didn't. The judge didn't calculate it that way. And it's fine.
Isn't that what Rosenberg says and what that footnote 1 in the guidelines say? That it's got to be treated as income to the non-custodial spouse?
Your Honor, what he did was attributed to the income to my client, the appellee.
Yes. Shouldn't he have attributed it? Why shouldn't he have attributed it to the father? And then treat it as a credit.
He should have attributed the father, which would have made him pay, would probably made him pay more. The calculation would have been increased versus decreased.
But then treated it as a credit, the amount of the dependency benefit as a credit against what the guidelines say the father should pay.
Yes.
I don't know how that calculation would come.
I agree with that, Your Honor, but we're talking about $39 here. That could, and I don't know whether the judge, calculated that to be $39 in favor of my client, because the 66-33 split on parenting time wasn't being adhered to. My client was caring for the child 100% of the time.
Okay, so let me ask, would you agree with this? We don't know what the effect of treating the dependency benefit properly under the guidelines and the Rosenberg case would be. It might be to your client's benefit, it might be to father's benefit. But the one thing we do know is that it wasn't treated in accordance with Rosenberg and the guidelines. Would you agree with that?
I could not agree with that because I've seen no evidence of that. And at trial, we saw no proposed calculations from father's attorney. I asked in discovery how father's attorney intended to calculate these, the guidelines. I asked in discovery in 2018, and unfortunately, father's attorney did not comply with that discovery request. It was the last discovery request I had for the request for production of documents. In fact, father's attorney was sanctioned by the court, and you can find that at Order 232, dated 10/12/18. I'm sorry, Your Honor. But We don't know because father's attorney didn't submit anything to the court. There was no testimony regarding back interest or back child support or back penalties. The DOR record wasn't introduced in the evidence. Father, during those times, was working. He admitted to as much. So if they're looking back to 2017, father made $19,000 that year. That didn't even enter in the calculation. That would he was attributed income far lower than that amount. In approximately at the minimum wage, $7.25 an hour times 40 hours. It was significantly less than he actually made. He was actually benefiting from this. I'm kind of surprised we're here. Father has not cared for this child, hasn't taken any time or sent money or presents beyond his child support obligations. We don't have anything in the record. We don't know what the judge heard at trial. We didn't hear what objections opposing counsel had to any of the evidence being presented. And it's not too difficult to get medical records into evidence under 79G. Father's attorney could have submitted those. She didn't. We don't have any evidence directed towards father that he cannot work. The only thing we have is his own testimony and the submissions by his attorney that he was working by virtue of receiving a W-2. We did not receive any records of payment Social Security had made. We didn't to him or to the daughter, to his daughter. You know, we were bereft of any kind of discovery or documentary evidence or even testimonial evidence. Father expects you, by virtue of him being on Social Security, to say that he's 100% disabled and then he cannot work, despite the fact that there's a total body of regulations and law allowing people on Social Security disability to go back to work. Father could not testify to any treatment he was receiving, any medication he was getting, any diagnosis for the future. He could not produce any medical records or did not produce any medical records. He's expecting, by virtue of being on Social Security, that he should be excused from working at all. And all those matters factor into the child support payment, which is a relatively low sum of $118 a week, plus the back child support that he does owe, while before he was
certainly without a transcript, there's a lot that we don't know. But can I just make sure that we're on the same page regarding the law rather than the facts? You agree that I'm asking you whether you agree that under Rosenberg and the guidelines, the proper way to treat a dependency benefit under SSDI is to treat it as income to the recipient of the SSDI, which is in this case the father, and then treat it as income for purpose of calculating the child support amount under the guidelines, and then take the amount of dependency benefit and apply it as a credit against the guidelines amount of child support as a general matter.
As a general matter, I agree on it.
And then secondly, would you agree that that is not currently being done?
I don't know that to be a fact. I haven't seen any calculations that the court did on the guidelines.
Didn't the judge say that at record appendix pages, I think at page 183, in the last paragraph, record appendix 1, page 183, in the last paragraph before conclusions of law, the court finds that father shall not receive a credit towards arrears, and the court notes that the amount mother receives from father's SSDI is calculated in her income for the purpose of the guidelines. So he's treating it as income to her, not income to the father.
We haven't seen how the mathematical equation will work out.
Correct, but he's saying it's treated as income to her, not him.
He did say that, Your Honor. I agree. But I'd like to bring to the court's attention that opposing counsel's briefs indicate stipulations of fact. And I just want you to know, and I put that in my brief, that the appellee has not agreed to any stipulations of fact listed on reply briefs, on the appellant's brief on pages 32, 33, 34, 35, 36, 37, 38. I think what the counsel's trying to do is substitute her version of the facts for what actually happened at trial. And I would find it very unfair that my client has to battle a will-o'-the-wisp here and not know exactly what counsel is trying to object to and what kind of evidence she actually presented at trial, which was very limited, but the transcript would reflect that. Because, I mean, I found the courts, the probate courts, to be very accommodating and allowed attorneys to, dial in by phone even before the pandemic. I am surprised that that didn't happen. I noticed that there was a hearing scheduled for this matter to get transcripts on October 12th, 2019, and counsel did not appear, and neither did her client. I didn't see anything in the record to indicate a motion to get a new date or do it by telephone, which is the normal procedure. You file a motion. And counsel even filed those motions when a client could not come to court. So, she looks like she made one attempt and decided to go without the transcript, which doesn't give the court much of an opportunity to review whether the judge abused his discretion or made an error of law here. I think given the imprecision of the child support, may present an issue for you, but I don't think it's that big of an issue because it could be easily explained by an honest deviation from the child support guidelines, accounting for Ms. Restuccia's 100% care of the child.
Actually, your time is up now, so if you don't have anything else, okay.
That's good, Your Honor. Thank you very much.
I'm going to check to see if the panel has any additional questions, just in case, and I see none. I want to thank you both very much for your argument. We'll take the case under advisement. We'll try and get an answer back to you as soon as possible. Just like to add on behalf of the panel that you know that the pandemic, we're still living under the strictures of the pandemic, so we hope that everyone stays safe and stays healthy. Okay.
Stay safe.
Likewise. Thank you, Your Honors.